What is a deposition and what does it consist of?
Have you ever heard the term deposition and you're not exactly sure what it means? If you're involved in a legal case, this is one of the most important steps in the entire process. Today, I'm going to explain what a deposition is, what it's used for, and how it is carried out step by step. A deposition is part of the discovery process. It is essentially a formal interview under oath, where the attorneys from both sides can ask you questions about the case, but outside of the courtroom. Everything you say is recorded or transcribed by a court reporter and has the same legal value as if you were saying it in front of a judge. The purpose of a deposition is to obtain information, clarify versions of events, and prepare strategies before trial. It also helps identify contradictions or uncover evidence that may strengthen the case. In summary, it is an opportunity for both sides to know exactly what evidence they have before going to court. Everything starts with a document called a notice of deposition. This notice is sent to the parties involved and to the witness 10 to 30 days in advance. It must include the date, time, and reasonable location, the method of recording, any request for documents if applicable, and the identification of any additional attendees. It is a formal process, and you must be well prepared before attending. What does a deposition consist of? Here is the step-by-step. Step 1. Notice. Your attorney sends you the formal notice with all the details. Step 2. Location. It can take place in an office, a conference room, or even via Zoom, never in court. Step 3. Oath. A court reporter places you under oath. Lying here is considered perjury, a serious crime. Step 4. Questions. The opposing attorney asks the questions, sometimes intensely. Your attorney may object, but you usually still have to answer. Step 5. Recording. Everything is recorded and officially transcribed. Sometimes it is also videotaped, especially if the witness may not appear at trial. Step 6. Review and signature. You have 30 days to review and correct minor errors, although you cannot change your answers. Step 7. Use at trial. If you cannot attend, your testimony may be read in court or used for impeachment if you change your version of the facts. As you can see, a deposition is a key stage of the legal process. Every word counts and can directly influence the outcome of your case. That's why it's essential to be properly prepared by your attorney before participating. At David Sanchez Law Group, our practice is to prepare our clients 24 to 48 hours before the deposition, so they have a clear understanding of what they will face and how to proceed correctly to achieve the best result.
He's the Texas rock star, el defensor, speaks Spanglish, fluido, straight from el corazón, calls you mi gente, rides for the just David Sanchez. A lawyer you can trust, con su chongo arriba y su mente clara. This is real talk, con ley y verdad.